I propose to deal with Cantor's points under the three headings: the natural and ordinary meaning of the words, the wider contractual context, and the factual matrix, including the genesis and commercial objective of the contract. And I will also deal with our respondents' notice points under those headings, rather than deal with them all at the end.
Yeah.
So first of all, the first point that Cantor makes is the width of the wording in paragraph 1 of the engagement letter, and what they rely on are the wordings in any form, which is in the context of the type of securities, and the words one or more financing in one or a series of transactions. I think Mr. Beltrami fairly accepted this morning. These shed no light at all on the meaning of financing. What they tell you about is the type of securities and the number of financings only. So those wide words we submit do not inform the meaning of the key words: private placement, offering, or other sale of equity instruments. The second point Cantor takes is the conventional understanding as to grammar. And this is the judge's judgment at paragraph 86. Where he said that where an adjective or determiner is followed by a series of nouns in a list, the conventional understanding is that it modifies all the nouns in that list unless a discordant adjective or determiner breaks that pattern. This is the subject of criticism in Cantor's skeleton paragraphs 30 to 34. None of those criticisms we submit are fair. First of all, it said that the judge cited no authority for the conventional understanding. Well, first of all, no authority was needed, in the same that none would be needed to express a view on the meaning of a particular word or phrase. But in fact, there are authorities, and we can go to one from the United States, where this grammatical convention has been expressly recognised. And we have that in the supplemental bundle of authorities. It's a case called Ryder versus USSA General Indemnity Code.
Yeah.
And it was an insurance contract case. And the key term, well, first of all, it's a decision of the Supreme Court of Maine before a panel of 5 judges. And we get that on page 2. So it was Chief Justice Soufflet and Justices Alexander, Levy, Silver and Mead. And the key question on the insurance policy is summarised in paragraph 13 of the judgment on page 5 of the bundle, where there was a phrase, bodily injury, in a car insurance policy, and the question was whether effectively nervous shock fell within this policy or not. And bodily injury was defined as bodily harm, sickness, disease or death. And the question was whether the word bodily applied to each of the following words. And the general principle was set out in paragraph 15 of the judgment, where the grammatical convention that Mr. Justice Bright referred to is cited. If I could perhaps just invite the court to read paragraph 15, which cites a number of cases which refers to this grammatical convention.
Yeah.
Now, in paragraph 17, the court went on to say that on the particular wording in this case, then there was some ambiguity as to whether the general grammatical rule applied, because if it did, then you would end up with a phrase, bodily death. And the court said, well, hang on. That seems to suggest that the usual convention can't be applied here, because what sense does bodily death have? And so they felt that the phrase was ambiguous and so didn't apply the general convention. But the point is, they recognise this as the starting point. When you see an adjective in a list of nouns, you start from the position that the adjective applies to all of them.
At least Americans do.
So,
At least Americans
well,
do.
they do, my lord. But also, we also have in the bundle Sir Kim Lewison's book on the interpretation of contracts at tab 1 of the supplemental bundle. Now this is the 2024 edition, 8th edition.
Got that? I don't have that.
It should be in the. Sorry, it's at the end of the.
The end of
original
the end of the other
Sorry,
bundle.
it's the. It's tab 9 of the authorities bundle. And
Yeah.
so if we have start at page 181 of the bundle, which is the start of the chapter entitled "The Meaning of Words," and,
Yes.
and we're all familiar with the way in which this book is structured. As the starting point gives us the proposition in bold: the words of a contract should be interpreted in their natural and ordinary sense in context, unless there is good reason to adopt a different meaning.
Yeah.
And then within that heading, one turns over to page 185, and we see that this case has been referred to by Sir Kim Lewison.
Yes.
The natural meaning of words will include grammatical conventions, thus in Cantor Fitzgerald and Yes Bank, Bright J said, and paragraphs 85 and 86 are quoted. Those are the paragraphs that Cantor now criticise.
But that's the only place, is it? He doesn't identify any other English authority which makes the precise point.
That's right, Lord. That's
Okay.
see.
Well, you can legitimately say that leading textbook has approved this decision at first instance,
Yes, Lord.
for what it's worth.
Indeed, Lord. Now, Cantor's skeleton at paragraph 32.2 criticises the judge's reference to this convention. He didn't describe it as an invariable rule, as Cantor suggests. The judge said it was something which allowed him to form a provisional view of the meaning of the words, which he did in paragraph 90, making clear that this was his provisional interpretation. Now, Cantor then go on in his skeleton to refer to a number of other phrases where they say, well, the rule doesn't apply. I'm not sure how much is gained by going through all of the different phrases, but we can take some of them. So 32.2a of Cantor's skeleton refers to every Tom, Dick and Harry, which they say is a well-known idiom, and takes us no further. But that rather misses the point. Everyone knows what that phrase means, and it's supported by and reinforces the conventional understanding that the word every applies to everything in the list. Even when that phrase was novel, the expectation would have been that the writer was referring to every Tom, every Dick, and every Harry. And the same can be said of negligent act or omission. The settled meaning of convention supports the understanding that negligent applies to negligent act and omission. Similarly, small, chair, table or lamp, the conventional understanding is that small modifies chair, table and lamp. But there can be exceptions, as we've seen from the Ryder case. If it makes no sense to apply the convention to a list of nouns, then obviously one doesn't apply it. And that's where Cantor's example of off-road cars, watches and other luxuries is an example of where you would not apply the rule that, or the approach that the judge adopted, because it makes no sense to refer to off-road watches.
Well, at least if you were looking at off-road cars and watches, I suppose, there's no obvious connection between cars and watches in the same way as there is between placements, offerings, and other forms of.
Precisely, my lord. And that is our point on this. That the word private can apply, and we say does apply, very easily to the word placement, offering, or sale of equity securities. The third point that Cantor makes in its skeleton, 32.2d and 32.3, is everything depends on context. And of course, we don't dispute at all that context can always affect the meaning of words and sentences. And the judge expressly acknowledged that in paragraph 90, where he said he was then going to go on and consider those words in context, and that's exactly what he did. We touched on this this morning, which is another clause within the contract, clause 5, and perhaps we should just look at that, because this is where the judge made the point, and this is on page 171 of the bundle, that paragraph 34 of Cantor's skeleton criticises paragraph 89 of the judgment about this clause. The judge pointed out that the grammatical construction used in this clause is also the one that's used in clause 1. It is entirely in line, we submit, with how a contract should be construed to look at how grammar has been used in other parts of the contract. One reads all of the contract to establish objectively what the parties intended, and if they've used a grammatical construct in one clause and used the same grammatical construct in another, objectively they intend the same principles of construction to apply to both clauses. So the suggestion in paragraph 34.4 of Cantor's skeleton that it was wrong for the judge to take this into account is, we say, without foundation. It's also wrong, as is suggested by Cantor, to...
Sorry, before you move on from paragraph 5.1, what do you say is the activity in relation to what kind of financing that's covered there?
Oh, sorry, on 5.1, my lord. So, sorry, yeah, I can deal with that now, my lord. So, 5.1, there was quite a lot of discussion about 5.1 this morning, and I don't think my learned friend came up with a suggestion as to what it might be referring to. One possibility would be that outside of the word, outside of financing, Cantor might be able to become regulated in India, for example, to carry out the kind of finances that it couldn't carry out.
Well, that would be a bit odd in a clause which is identifying what they have a right to do.
Well, it's the right but not the obligation, and if after a month or two or three or however long Cantor became regulated in India, set up an Indian office and was actually regulated to carry out other financings than it was, then it would say, well, we have the right now to act as lead book running manager for this other financing, which is not falling within financing capital F, but something different, which we're now able to do, and we'd like to exercise our right to take up the role of book running lead manager on that other financing.
And what kind of financings contemplated by Indian law would use a lead book running manager?
Well, that was the judge held in 79.5 that it was not a term of art in India.
So the answer to my question is,
Well, it is,
Contemplates that the book, that they're running a book, isn't it? Which is what, at least on one view, the schedule to the agreement does.
Building a list of
Building a
interesting
list of investors.
of potential investors.
I mean, it doesn't. I mean, the difficulty, in a sense, is that if Mr. Beltrami is right, it's difficult to see what meaning it has anyway.
well, that's the point.
Because
Yes.
financing on his case includes pretty well everything.
Well, it does include everything, Lord, and that's absolutely
So
right.
you
It
then
includes
ask yourself the
everything.
question: what is a small f financing that isn't a capital F financing?
Yes, and so our suggestion is that it is something which Cantor was not authorised to do at the time the contract was entered into, but in due course it might.
But is it necessarily limited to that? Because if you read, you're assuming that assumes that to be a book running manager you need to be registered in India.
Yes,
Whereas it's an undefined term,
Yes.
it could just mean putting a list of investors together, drumming up interest.
it could.
Yeah.
If that's the case, doesn't 5.1 assist you rather more than you're indicating?
It does, my lady. We do say it supports us, and in fact, the judge, I think himself, felt that it did support our case more than Cantor's.
Where is?
well,
Can you point us to where that's?
It's paragraph 104, my lady.
Thank you.
And we do say that is the least that can be said about this clause, but actually on one view it's incredibly supportive of our case, and that is our submission, that why on earth include this clause if financing on the learned friend's case refers to all types of finance that you can have for this company. Why have you bothered to put in a clause like that at 5.1 if they've already got the right to perform that role in financing? So it's the second point which arises out of clause 5 is one which was touched on this morning about the grammatical construct in Roman numerals 2 and 3, which applies the adjective non-domestic to each of the words acquisition, disposition, or other extraordinary corporate transaction. So that's Roman numeral 2, which is talking about non-domestic acquisitions, dispositions, or corporate transactions, and Roman numeral 3, which talks about domestic acquisitions, dispositions, or other extraordinary corporate transactions. And Lord, I don't want to labour the point, we've already gone through it once, but that is exactly the same construct as we say is used in paragraph 1. You have the adjective which affects each of the nouns afterwards, and the learned friend can't say that doesn't apply in this case because Roman numeral 2 deals with non-domestic acquisitions, dispositions, or corporate transactions, and 3 deals with domestic ones. So,
Well, even if 3 weren't there, you would say that 2, the clear meaning of 2 is that non-domestic qualifies
precise, my lord. Yes,
all 3.
yes,
Yeah.
exactly. Looking at clause 2 on its own, that's the natural
Doesn't
meaning
make
of it.
sense otherwise.
3 means that even a learned friend can't argue that that's not what the grammatical construct is used. So just dealing with some other points that Cantor makes in relation to the judge's point that the same grammatical construct was used. They say in paragraph 31(4) that there was no evidence at trial on which the judge could have based his conclusion that the parties deliberately used the grammatical formulation in paragraph 5. And it is suggested by Cantor that paragraph 5 is boilerplate drafting. Those submissions we submit are wrong. Clause 5 is not boilerplate drafting. It's a bespoke clause which refers on 3 occasions to the definition of financing in paragraph 1. And we don't understand why Cantor criticises the judge's use of the word deliberately when describing the grammatical construct was used deliberately.
I don't know why you say the reference to capital F financing means it isn't boilerplate.
Sorry.
I don't know why you say that the fact that it refers to capital F financing prevents it from being boilerplate. That may be the boilerplate way of dealing with this. You have a letter which identifies what the financing is that in respect of which Cantor Fitzgerald are going to act, and then you have these annexed clauses which deal with rights other than that financing.
Well, my lord, we've got.
It's not as though there's some reference to private placement, anything like that. This could well be a standard clause which appears in all their letters, where the letter itself identifies the financing, and this identifies rights outside the financing.
Well, my lord, that's
And it might have more significance and meaning in a different context in relation to another jurisdiction where they didn't have a restriction on their participation. And I'm not sure it makes much difference really, because in a sense, and this is the agreement, whether it's bits of it are boilerplate or not, it's neither here nor there.
yes, and
We don't know. I mean, there wasn't any evidence. Nobody did the sort of trawl through to say, well, you know, these clauses appear in all Cantor's documents or whatever. I mean, one looks at it and you can see some of the provisions look horribly familiar from other contexts, but not all of them do.
Well, just in relation to Lord Justice Popplewell's point, we would still make the point about the grammatical construction that has been employed in both the clauses, which we think is of some weight when one is trying to construe paragraph 1 of the letter. Moving on then to another point that Cantor makes in its skeleton. This is paragraphs 35 to 37. This is its submissions on private placement in paragraph 1, having a meaning which is a term of art from the Indian Companies Act. Now, the judge rejected that argument, and we respectfully submit for the right reasons at paragraph 79 of the judgment. And if one goes through why the judge came to that conclusion at 79.1, it's accepted by Cantor that the point the judge made in 79.1, that private placement is also widely used in other jurisdictions, is correct. 79.2, no challenge to the judge's finding that the word offering is widely used and is not a term of art under Indian law. 79.3 makes the point that the words in the second sentence of paragraph 1 of the engagement letter are also not terms of art under Indian law. That's financial advisor, placement agent and arranger. Those are Indian terms of art. 79.4 contrasts these phrases with the use of the capitalised term quip in the third sentence. Now that is being used as a term of art. And as my Lord Justice Popplewell commented this morning, it is relevant to note that the parties have capitalised QIP. It's also specifically referred to on page 178 of the engagement letter in the annex A, which I think we have looked at, and I'm not sure we need to turn it up, but is undoubtedly being used in the sense of how it's defined in the Companies Act. But it is worth observing that within Indian law, qualified institutions placement is not a capitalised phrase.
No.
And we get that from the supplemental bundle at page 87. So I'm not sure there's any need for me to go to that. They could, of course, but they didn't capitalise the words private placement, indicating a different treatment in our submission. Paragraph 36.4 of Cantor Skeleton seeks to suggest that the words used in paragraph 1 of the engagement letter are broadly consistent with the words used in section 23 of the Companies Act. I think it would be worth looking at section 23 of the Companies Act. So that's in the supplemental bundle, and what is instructive is to compare the words in the engagement letter with the words in section 23 of the Companies Act. So it's page 28 of the supplemental bundle. This is the Companies Act, paragraph 23. Starting with paragraph 23A, 1A. That refers to a public offer. Cantor's case is that rather than use that phrase, the engagement letter use the word offering. So offering is meant to cover private offer. And the obvious point is, if that was the intention, why on earth have you left out the word public? In fact, if one is looking for the word offering in the Companies Act legislation in India, one can find it, but one finds it in the context of a private placement. So if one turns to page 136 of this bundle, sorry, it's page 36. 36, my lord. 36 starts with, about a third of the way down, you have the heading private placement. This is part 2, and this is the section dealing with private placements. And you see there at section 42, private placement, offer or invitation for subscription of securities on private placement without prejudice to the provisions of section 26. A company may, subject to the provisions of this section, make private placement through issue of a private placement offer letter. And if one goes over the page to subparagraph 8, it says this: no company offering securities under this section shall release any public advertisements or utilise any media, marketing or distribution channels or agents to inform the public at large about such an offer. So that's the only place that we can find where the word offering is used, and it's used in the context of a private placement, not a public offer.
It's not using it as a noun.
No, my lord, no. It's making the point, though,
as a participle, or gerund. But it's not, yeah, I mean, you can certainly find the word offering in the
Yes.
Companies Act, but I'm not sure, unless it's used as a noun, I'm not sure how it helps, really.
What's the difference, on your case, between a private placement, which is the first phrase, and a private offering, which you say is the meaning of offering in the next thing? What would be a private placement but not a private offering, or vice versa?
Well, the words private apply to placement, offering and other sale, and it is a way of drafting that ensures that any kind of private transaction is caught by paragraph 1.
Well, give me an example. What would amount to a private offering, which would not be a private placement, or vice versa?
Well, my lord, the judge gave an example of something that could fall outside of the word private placement, and we'll come on to that, where he talked about, for example, an agreement, a contract between the company and a private investor, which requires the company to enter into a preferential issue, but also obliges it to then immediately engage in a rights issue, for example. Now that would, strictly speaking, fall outside private placement, and it is what the judge held those words outside of private placement meant in his judgment at paragraph 94(3), I think it is. So it's 94(3), on page 111.
Yeah, he says, doesn't he, that it would still be useful to capture a preferential issue coupled with a rights issue.
Yes. So this is his composite or hybrid transaction, where the company is obliged, first of all, to bring in a new investor through a preferential issue, but with an obligation that as soon as they're within the tent as a shareholder, then they are entitled to take up rights as a shareholder. And the judge held, well, that is the type of transaction which, strictly speaking, would fall outside of the strict definition of private placement, but would be one which...
Yeah, just pausing there, when you say the strict definition of private placement, the starting point for your argument is to say that private placement doesn't have
You're
its
absolutely right.
technical
Exactly.
Indian
it was,
meaning, has a more,
it does.
and therefore potentially a more limited meaning than the Indian.
Yes, yes. This is really picking up, you're absolutely right, my lady, that's exactly right. This was just picking up Lord Justice Popplewell's point about, well, can I name an Indian transaction which would not fall, a private Indian
Why
transaction?
wouldn't it be a private placement, what I've just described? Private placement is not a term of art, it's not an Indian term. It's a placement which takes place privately. Why would this not cover that?
Well,
I'm just struggling at the moment to see on your interpretation why you've got placement and offering treated as separate concepts.
well, my lord, as the judge, I have given you some examples of different structures of transaction, and they were, in my submission, adopting a belt and braces approach to ensure that however you structure a private transaction, it is going to be covered by this wording, private placement, offering, or other private sales. And it was to avoid arguments about whether a transaction which was entered into between the bank and the investors that Cantor introduced to it, as to how that was structured, that they used those words to ensure that it covered all kinds of private agreements that they would make.
Was there any general evidence before the judge about what private placement is commercially understood to mean as against the section 42 definition?
No, my lady, it was just generally accepted that it's a word that is used around, is understood around the world, but in not a precise
Okay,
definition.
so its confines or extent weren't really explored.
They weren't, my lady, no.
Thank you.
No.
Yeah.
But placement means placement by the company, not placement by the advisor. So it's
Yes,
talking about
yes.
it's talking about new equity,
Yes, my lord, yes, it is.
which is by definition being offered by the company to somebody.
There we are. It's you have my submission on the approach the draftsman took to ensure that all private kinds of transactions of structure were covered by paragraph 1. At the same, just returning to section 23 of the Act, just we started off looking at how Cantor says that section 23 of the Act is reflected in the wording used in the engagement letter. So we've seen that the word, on their case, public offer, is instead referred to as offering in the engagement letter. We then come on to 23C, which deals with rights issues. We'll see how those are defined in 23C. A rights issue or a bonus issue in accordance with provisions of this Act, and in case of a listed company or a company which intends to get its securities listed, also with provisions of the Securities and Exchange Board of India and rules and regulations made thereunder. Now, that concept, Cantor says, falls within, is meant to be captured by the words other sale. And the disparity between those words is obvious, indicating we say that it cannot possibly have been the intention to try to capture the different forms of financing in section 23 by the wording used in the engagement letter. So just returning to my lady's point that the word, in the judgment paragraph 94.1, the judge said that private placement is a phrase in general worldwide use amongst professional people with a financial background, just as professional people might use the phrase private offering or private sale. And once one accepts that the words private placement are not being used as an Indian term of art, or indeed any term of art, there is nothing to displace the judge's conventional construction that the word private modified all the nouns in the list. If I can move on to another point that Cantor makes about rights issues. Cantor's submission is that a rights issue falls within paragraph 1 of the engagement letter. It is a financing. In fact, it says that all forms of finance, however they're described, fall within paragraph 1. And its argument on rights issue is to try to force rights issue into paragraph 1, to then effectively open up and crowbar up the definition of financing to include an FPO. The reasoning seems to be, well, if a rights issue is in paragraph 1, then so should an FPO, because it's not confined to private financing. There are several steps in this analysis which we need to understand, and I'll take it to how the judge dealt with it. So step 1 is that Cantor makes an argument against redundancy of the language in clause 1. So it says that if private governs offering and other sale, they would have no separate meaning because all possible forms of private financing under Indian law would be covered by the phrase private placement. The second is for them to say that if the words offering and other sale are to mean something different from private placement, the only candidates are rights issue or public offering. Third, Cantor then seeks to characterise a rights issue as non-private. It's described in its skeleton as sui generis. And so the argument goes, a rights issue, if it falls within the scope of clause 1, then it must be wider than private forms of financing. And then the fourth step is to conclude that if clause 1 includes a non-private financing, i.e. a rights issue, then it cannot exclude a public financing. Now, as Lady Justice Falk mentioned this morning, this is somewhat a very odd argument, because the judge found that the commercial objective of Cantor's appointment was to bring in new investors from the list of potential investors in Schedule 1. It was certainly not appointed to carry out a rights issue, which by definition is to a sale to existing shareholders. In fact, Cantor did not have regulatory approval to advise or act as a placement agent or arranger of a rights issue. And this complicated approach, as we say, misconceived. The first problem is, as the judge pointed out at paragraph 94.4, Roman numeral 4, the argument based on redundancy is generally weak. That was a reference back to the judge's judgment at paragraph 84, where he cited the case of Arbuthnot and Fagan and the Supreme Court decision in the triple point technology case, to the effect that arguments on redundancy are seldom decisive and often have no weight at all, because contractual draftsmen often err on the side of repetition to avoid any loopholes. That's a general principle. It's not, as Mr. Beltrami suggested this morning, one confined to settlement agreements. That's a general principle. And that is the style of drafting adopted by the draftsman in this contract, as the judge held at paragraph 81.2. Belt and braces approach to drafting was used. The draftsman here used the words private placement, offering or other sale of securities to ensure all forms of private finance were caught by paragraph 1. That's an entirely rational and correct analysis, standing in stark contrast to Cantor's attempt to shoehorn into paragraph 1 of the engagement letter a rights issue under the rubric of this being an other sale of equities. The other problem with Cantor's submission is that in paragraphs 39 and 42 of its skeleton, it bases its argument on the premise that at paragraph 94, the judge decided that a rights issue did fall within the engagement letter, while an FPO did not. But that's not a correct reading of paragraph 94 of the judge's judgment. He didn't decide that a rights issue fell within the engagement letter. He didn't have to decide that. What he did in paragraph 94 was test out whether Cantor's submissions on rights issue affected the ordinary and natural meaning of the words. And he dealt with that argument by considering the alternatives of a rights issue being a form of financing, private financing, and it not being a form of private financing. And he did that because, as I've said, one of the steps in Cantor's arguments is to say that a rights issue is not a form of private financing. And the short point is, whether it was or it wasn't, makes no difference to the judge's view of the ordinary and natural meaning of paragraph 1 of the engagement letter. The judge alternative analysis is in 94.2 and 94.3. 94.2 deals with Cantor's suggestion as a rights that it is right to say that a rights issue is not a form of private financing. He wasn't convinced that was correct. He said it was not obviously inaccurate to describe a rights issue in that way. So he didn't agree with step one of Cantor's argument on rights issues. That was enough to deal with the point as a matter of construction, because it was not a sufficiently strong point to displace the natural meaning of the words as found by the judge. At 94.3, the judge then considered the alternative position that Cantor was correct to say that a rights issue was not a form of private financing. As we've seen, that did not mean that offering or other sale were redundant. And we've been through the utility that the judge was referring to of a hybrid sale. There was a preferential issue coupled with a rights issue as part of a single agreement with an investor. The judge held that a hybrid contract of that kind would be a private offering or other private sale, even if it wasn't a private placement.
Mm.
Now, Cantor has criticised the judge's judgment on hybrid contracts. It says in paragraph 41.1 that a hybrid contract falls outside of. It says that there's has to be a single offering or a single sale under the engagement letter, and it can't include two forms of financing at the same time. But there is no problem in describing a contract with two components as a private offering or a private sale. Paragraph 41.2, Cantor in its skeleton says that a rights issue cannot be converted into a private financing merely because it follows or precedes a preferential issue. That's not what the judge was saying. The judge was considering an agreement between Yes Bank and an investor under which the bank committed to sell a certain number of shares to an investor under a contract which obliged the bank to issue a certain number of shares to that investor by way of a preferential issue and then allow them to buy shares under a rights issue once they were a shareholder. Now, the reason why an investor might want to do that, enter into such a hybrid transaction, is that it would benefit from the lower share price that could be offered to them once they were a shareholder. And such an agreement would fall within the meaning of private offering or private sale. Just as a point of detail, under a preferential issue, there are pricing restrictions as to the offer price that can be offered by the company. Basically, they had to offer the highest price over an average of the last 26 weeks before the offer, or the highest price within the last 2 weeks before the preferential issue, whichever was higher, and that's regulation 164.1 of the SEBI regulations, which is at the supplementary bundle, tab 2, page 82.
Sorry, which regulation?
So this is the SEBI.
Just give me the regulation number.
164.
164, did you say?
164.
Thank you.
Yes.
Pricing of frequently traded shares.
Now, in paragraph 41.3, should we turn that up, my lord?
No, I just when the definition of preferential shares is refers to chapter 5, and chapter 5 it is that section you just referred us to is in chapter 5. That's all I was just checking.
Yes, and it's section 164.1.
Yeah.
which puts in a restriction as to what the price can be if you are offering shares on a preferential issue basis.
Yeah.
That restriction wouldn't apply once you come into the company. And so with the share price decreasing, as time went on, one can see why an investor might want to enter into some hybrid transaction of that nature. Now, paragraph 41.3 of its skeleton, Cantor says the same logic would apply to an agreement to issue shares with a preferential issue followed by an FPO. But that is not right. An FPO is a fundamentally different transaction to a rights issue because it is available to the public at large. A bank could give no commitment to any investor as to the number of shares they could buy in a public offering. An agreement which includes a promise to embark on a further public offering cannot be said to be a private sale or a private offering. But perhaps the most significant problem with Cantor's submissions on rights issue are that they are entirely disconnected from the commercial purpose of this contract, which the judge addressed in paragraph 118 of the judgment, where he said that the parties cannot have had in mind using Cantor to help with a pure rights issue, not merely because this, like an FPO, would have required an Indian registered merchant bank, but also because a rights issue must be offered to existing shareholders, i.e. not the new investors that Cantor was intended to introduce. The investors to be identified in Schedule 1 would only be able to subscribe to a rights issue if the existing shareholders renounced their rights to do so. It cannot have been the party's intention that Yes Bank should launch a rights issue with all the publicity that this requires, positively hoping that the existing shareholders would refuse to participate. Now, there is no appeal against that aspect of the judgment.
Is it right? What about the example I gave of someone purchasing shares before the record date? Whether the public could take part in the rights issue in that way.
Sorry, the example of...
If you announce a rights issue, there is then a later record date, which is the date on which the shareholders have the rights to take up the additional shares. And any member of the public could purchase shares in the market before that date, so as to take advantage of the rights issue. Not only renounced who could be members of the public who can take advantage of a rights issue.
But the relevant agreement would be the agreement between the company and Cantor's investor. And the relevant agreement would be that shares would be acquired under a preferential issue with the investor then able to take up their rights, with the intention of taking up their rights.
Yes, I mean that's the pure hybrid example starts from that premise that you have a preferential issue first under an agreement with the company.
Yes.
But the rights issue element doesn't itself have to be private in that sense, does it? And it doesn't have to be private.
What's
only
sorry.
reference to the position of renounced. The public can take part in the rights offer by buying shares before the record date, if they're listed shares and they're freely tradable.
Well, but that would be something outside of the agreement that had been reached between the bank and the particular investor. I mean, there is a chance.
This is not directed to the hybrid example. It's directed simply to whether a rights issue is or is not private or public. The point the judge was making in the passage you took us to rather seemed to assume that it was only by virtue of an ability of renounced to take part in the rights issue that they had any public element at all.
that would,
It may not undermine your point, but
No.
you said there's no appeal against that
No.
finding of the judge, but I'm not sure I entirely agree with it.
all right. Well, my lord, but in terms of what the judge found in paragraph as to what Cantor was appointed to do, surely he was right to say that they were brought in to bring in external investors. That was the commercial objective. They needed new capital. It wasn't the intention to Cantor to try to approach existing investors. There was a list of external investors that they were going to try and bring in, which is why we say
Well, new money into the company.
new money into the company from Cantor's book of investors, new investors.
Well, there wouldn't be the obvious financial advisor to use for a rights issue, even if they were authorised to act in India, because the bank would be more likely to use its previous and existing advisors who were au fait with who the shareholders were.
Indeed, my lord, and one of the points that the judge makes in paragraph 118 is in fact that Cantor was not regulated to do anything on a rights issue.
No.
The shares were in fact listed on the Mumbai exchange, weren't they?
Yes,
Yeah.
that's,
They could have been dual listed, could they?
we didn't go
As
into
a
that.
rights issue, they could have been dual listed in New York, say?
Well, my lord, that was certainly not something that was ever contemplated in.
I'm not sure whether it's right to assume that any rights issue would only take place in Mumbai. I suppose that's right.
That was not something that was gone into at trial, my lord. So, all of Cantor's arguments around rights issue, we say, really are wide of the mark when no one was envisaging that Cantor would be involved in a rights issue. And there really is no basis, we say, for overturning the judge's decision by reference to Cantor's arguments on rights issues, where it wasn't regulated to carry one out, it wasn't appointed to carry one out, it was appointed to bring in new investors. That was the whole commercial purpose of bringing them on board. Could I now look at some wider contractual provisions in the contract? First of all, the duration of the engagement letter. It said that because the contract was lasting 9 months, this supports Cantor's argument that financing includes an FPO because something might happen in the future over that time. The judge was right, we say, in 105 to say that the length of the contract in clause 6 does not affect the construction of the key words in clause 1. All it means is that any private financing that took place within 9 months would fall within the engagement letter. There could have been a series of private financings over a period of months. Indeed, paragraph 1 contemplates more than one private financing. An obvious example could be where a private placement is made to provide some initial capital to shore up Yes Bank's precarious financial position, followed by another private placement on a firmer financial footing. And we do say the burden is on Cantor to show what the parties contemplated at the time. It's not, and they have not shown that anyone contemplated an FPO either at the time in December 2019 or at any time subsequently. And if they were going to make a case that this was something that the parties were catering for, it was up to them to produce some evidence that this is what that the parties had contemplated. But in fact, what the judge's findings are completely contrary to Cantor's submission. If we look at paragraph 136 of the judgment, the last sentence, his construction, he said, was supported by the surrounding circumstances from which it was obvious that a public offering, including an FPO, was not viable as matters stood in December 2019. If one goes to 117, last sentence of 117, by contrast, they could have ruled out an FPO, and both, in fact, appear to have done so.
Is that referring to the entire duration, or is that simply the parties, the stance they were taking in relation to the immediate position in December?
That is the state of the evidence, which is why I make the point that if it had been contemplated that Cantor would be acting on an FPO, the burden was on them to produce some evidence that this is what the parties were contemplating, and they didn't. And in fact, the evidence all showed that, in fact, they had ruled out an FPO, and we'll come on to some documents later on to show Cantor's internal documents positively ruling out an FPO as being something that was even possible.
Over the next 18 months, or in the then circumstances, which I think is the critical distinction
Well,
which Mr. Beltrami would draw.
Well, as I say, there was no evidence that the ruling out was time limited. It was ruled out. So it's ruled out now, and it's ruled out for the duration of the contract. If one was ruling it out only for a limited time, one would expect that to appear in the documents, but it didn't. It was just simply ruled out. Cantor did no work on it. And that's where the evidence lies, and the judge was absolutely right to make that finding of fact, that no one envisaged an FPO, not now, not next month, not ever. So, Robert, moving on then to paragraph C of the annex to the engagement letter. Now, this is part of Cantor's case that the contract is wide enough to cover a public offering, and they seek to rely on paragraph C in the annex. This is in fact something that we rely on in our respondent's notice, which is to say, well, this is a clause which rather supports our case, because within clause C of Appendix A, the only reference you see is to private placement memorandum. Now, it's right, that is not a term of art in Indian law, that's a point in our favour, but nowhere in there is there any reference to a prospectus, which is the document that would have to be issued if one was undertaking an FPO. The FPO in this case had a prospectus which was over 500 pages long. Why, if the engagement letter was appointing Cantor to have any role on an FPO, is there no reference at all to a prospectus?
Why on your case is there, both in Roman 1 and Roman 3, very wide wording which would cover the prospectus?
Well, my lord, it's that is indeed what the explanation is to. There is no silver bullet in this case, my lord, in terms of a clause which definitely says, oh, paragraph 1 must be dealing with private. It's just another point which we say supports the construction.
I understood Mr. Beltrami's argument essentially to be defensive and say this is neutral. the mere reference to private placement in Roman 2
Yes,
doesn't indicate that what is being ruled out are public
right.
matters, because Roman 1 and Roman 3 are wide enough to cover all kinds of information in relation to public offerings. What I'm seeking to understand is whether you say it's neutral, or whether how
We say-
how you say the mere existence in Roman 2 of one of 3 forms of public information,
Yeah.
3 forms of information,
Well,
points in your favour.
it's only that they have identified a private placement memorandum, but no one thought to identify a prospectus. That's all. That's where it goes. These are all indications, we say, which is that this was to do with private financing, not public. The next point is one that was touched on this morning, which is this is at ground 2 of our respondent's notice, which is the weight that should be attached to the fact that in paragraph 1 of the engagement letter, the role of Cantor, if there is a quip, is specifically reduced down from being financial advisor, placement agent or arranger to simply offshore financial advisor. And offshore financial advisor, we say, is simply a euphemism for somebody who's going to introduce a potential investor. Now, I think I can take this fairly shortly because the court went through it this morning, but the point is that in order to, Cantor could not carry out the role of financial advisor, placement agent or arranger on a quip for regulatory reasons. It couldn't carry out the role of financial advisor, placement agent or arranger on a further public offering. Why then, in paragraph 1, did the parties specifically pare down its role in a quip to offshore financial advisor, and yet say nothing about what its role would be in an FPO, where it can't act as a financial advisor, placement agent or arranger?
To the extent it's relevant, we could make a similar point about rights issues, couldn't we?
Talking about preference.
I could indeed, lady, yes. Yes, I could. And just looking at some detail of the wording, which is in paragraph 1, and it's the second sentence, which is 4 or 5 lines down, where it says the company hereby engages Cantor to act as the company's financial advisor, placement agent and arranger in connection with any financing with any investor other than a quip. So that is positively saying, if Mr. Beltrami is right that a FPO falls within this clause, then it is positively saying that Cantor will act as a financial advisor, placement agent and arranger on an FPO. And Cantor accepts it cannot act in those roles because it was not regulated to do so. So this clause did 2 things in respect of a quip. First of all,
So sorry, are you saying that something can only be a financing if Cantor is able to fulfil all 3 functions, financial advisor and placement agent and arranger? Or is it enough if it's able to fulfil one of those 3 functions?
we do say it was being appointed to all 3 roles, but even if it's...
No, but there's a difference between being appointed to all 3 roles, any 1 or 2 of which may be relevant to,
Well,
but not all 3 of them, and saying they are only appointed in relation to financings in which they can perform all 3 roles. Are you saying the latter?
well, that is what this clause, in my submission, does mean, my lord, that they are being appointed as financial advisor, placement agent and arranger on the financings that they can do, and they could perform that role in relation to a preferential issue. There's no doubt, there's no question about it. They could do all of those things. But they couldn't do any of those things in respect of an FPO.
When you say you couldn't do any of those
Yes.
things, well, that's not entirely true about financial advisor.
Well, my lady, what we say about that is that if Yes Bank was conducting an FPO, it would have to instruct an Indian merchant bank. They would be the person that would give the Indian financial advice.
Well, okay, that goes further than we actually know, doesn't it? I mean, you can have all sorts of advisors as well as a merchant, Indian merchant bank.
The reason why we suggest that it's talking about financial advice in the context of the Indian regulations is because when one looks at how they defined Cantor's role in this, in the event of a quit, they were referred to as the offshore financial advisor.
Can that not include giving advice as well as referring investors? I mean, look at paragraph 2A, which is one of the functions that they're going to perform, which is a review and analysis of the business, financial condition and prospects of the company. That's just general financial advice for any purposes and could take place in the context of any sort of fundraising, couldn't it?
One Lord,
Whether you're the leading book runner, you're the merchant bank, or whatever you are, you can simply be a private advisor in that capacity.
well, one Lord, if there were an FPO, they would not be able to provide any meaningful review or analysis of the business, financial condition or prospects of the company. The Indian domestic merchant bank is required to carry out due diligence on all of those matters.
Maybe so, but where's the provision in Indian law that would prevent them doing what clause 2A identifies?
It's much more 2A is much more strategic than you'd expect the due diligence role to be. It's advisory. That's different. But I mean, maybe you don't need to go this far. I was just taking issue with your reference to not being able to do any of those three in
Yes.
relation to an FPO.
If advice could be given, as Justice Popplewell suggests, we're still left with the point that for a quip, they decided to give Cantor the role of offshore financial advisor.
Well, they had to be an offshore financial advisor because they weren't qualified to act
Indeed,
within India.
indeed.
And your best point is, well, if that was the position with a quip, and it was intended that the FPOs were covered as well, they should have jolly well said so.
Well, that's it, Lord. Yes, that is the point. Yes, which I'm labouring too much, but that's
the real point, isn't it?
that is the real point, my Lord. Yes.
I mean, why on earth, as it were, isolate the quip and put in place a quite a elaborate and detailed provision about it, if in fact you were going to you were already including within the opening words of the clause an FPO. It just doesn't make any sense at all.
And it just entirely, my Lord, this is our point. Why?
Seems to me that's your best point.
Indeed,
And that's just my personal
indeed. And
perception.
could I just add just one other thing before we move on, which is that they were also clear as to how Cantor would be paid if it was acting as an offshore financial advisor to a quip. The very last sentence says you will get a referral fee. So what's very odd about Cantor's case is that it says an FPO falls within this clause, but it doesn't define its role, and it doesn't say how it will be, what its remuneration will be, the basis of the remuneration.
It's slightly odd that you have that provision at the end of paragraph 1, when the fee is to be the fee that would be recovered anyway, unless possibly that when it says any such investors participate, it is intended to have a cause development, and as such refers back to investor referrals.
Well, yes,
And otherwise, because 3B is the fee apart from the lump sum retainer, I wouldn't have thought it was necessary to say anything about the fee in the case of a quip otherwise.
That last sentence isn't really required, is it? Because a quip is obviously a form of private placement, so it's within the opening words, and then it's specifically defined, and it's making clear that it has a kind of special status, if I can put it that way. I mean, I suppose it's for the avoidance of doubt, in case anybody came along and said, well, you're only an offshore financial advisor and not a financial advisor, so you're not entitled to be paid
yes,
any more than the initial
yes,
500,000.
yes. Just to note that Cantor's skeleton gives Cantor two different roles in the event of an FPO. Paragraph 19 of its supplemental skeleton describes it as an offshore financial advisor if there's an FPO. Paragraph 21 says that it would act as an introducer if there was an FPO. Even now, doesn't know what its role would be in an FPO. Neither of those words appear in this clause describing its role in an FPO. Could I move on to another textual point which the Lord referred to this morning, which is Popplewell, which is footnote 2 in the engagement letter. And it is absolutely right that at trial it was accepted that the meaning of financing was the same on the 18th of December when the contract was signed as it was when it was amended. It hasn't been suggested that any different meaning of the word financing. And the schedule is referred to in paragraph 1 on page 169, 5 lines down. The company hereby engages Cantor in connection with any financing with any investor defined in Annex A and Schedule 1. One then goes over to page 175, Annex A, paragraph A. It's the very last sentence of paragraph A. For purposes of this agreement, investor means any investor that is not a person resident in India in terms of applicable Indian and foreign investment related laws as set forth on Schedule 1 here too. Schedule 1 is at page 184. It was blank when the contract was executed in December. Footnote 2. It's already been pointed out that this refers only to private forms of financing, which is a quip and a preferential allotment. Now, as we heard this morning, a preferential allotment has a numerical limit of 200. That's in the judgment, paragraph 10. There wasn't a limit on the number of companies that could participate in a quip, and I think Mr. Beltrami accepted that towards the end of his submissions, that there is no numerical limit on how many companies can participate in a quip, and we can see that from the supplemental bundle at page 174. which is the Prospectus and Allotment of Securities Rules 2014. Perhaps if we start on page 200.
I'm sorry, Mr. Taylor, where is the provision that says it's limited to 200?
So this is, I think this is the clause that we're about to look at. So it's page 173 of supplemental bundle, which is under the heading private placement.
173.
Yep. So private
We
placement.
saw a limit of
Yes.
50 in the legislation, didn't we?
Yes,
Subject to regulation.
Precisely, my lady. And then this is this regulation. So 14.2 says a company shall not make a private placement of its securities unless, and then one needs to go over the page to B, such offer or invitation shall be made to not more than 200 persons in aggregate in a financial year, provided that any offer or invitation made to qualified institutional buyers or to employees shall not be considered while calculating the limit of 200 persons. So if you are a qualified institutional buyer, there is no limit as to how many can participate.
So if it was a quip, there wasn't a limit.
Yes.
If it was a preferential allotment, there was a limit of 200.
200.
And that's what the footnote's alluding to, is it? That it's
That's
saying
what we say, my lord, yes.
if in the event a preferential allotment is pursued, then Cantor can revise the schedule so that it doesn't
exceed
the 200
Yes.
limit.
Exactly, my lord. Yes, that is the point.
And that's why it talks about to reflect the more limited scope of permitted outreach.
Exactly. And the reason why they did that was so that this wouldn't, in my learned friends' words, trip over into a public offer.
That assumes, does it, that Cantor's role was to involve all those who are identified as investors, not only part of, seems like this.
Well, what I think it was getting at, my lord, was if you had a list of investors of longer than 200, then there was an issue if you wrote to more than 200 with a private offer. That would then trip it into a public offer.
If out of the 400 you identified in the schedule, only 200 took part, there's no problem.
I think it's
So
well. My understanding was it's
is
the
it
number
the
of
offer
people who
rather than
send.
those who take
I
part?
think it's the number
It
of people who
says
send
that
the offer
such
to.
offer or invitation shall not be made,
Yes.
should be made to not more than 200
Yeah.
persons.
So that
You can't make the offer to more than 200.
exactly.
But the assumption therefore is that Cantor were obliged to make the offer to all those who were listed, not any 200 who they selected from 400 on the list, say.
Well, I'm not. That is probably the.
Because otherwise there wouldn't, I mean, what's the
No,
point?
no, and of course, Lord, but it is. I think the rationale for why that footnote is there, in my submission, is to limit the number of people to whom an offer would be made.
But it'll only do so if there's an obligation to offer to everybody in the schedule. Otherwise, it isn't a limitation at all.
Well,
if Cantor are free to offer to any 200 out of 400 people in the schedule, there's no problem in having 400 people in the schedule.
Yeah,
Is there?
well, I understand that
More the
point.
merrier.
The more the merrier.
But
Um,
all I'm suggesting is that why did they go to the trouble of saying that people could be pulled out of this schedule? And that, in my submission, is the only rational explanation that has been provided for that footnote, which is that they wanted to ensure this did not inadvertently turn into a public offer.
what might it mean? At the moment, we're just going to put quip qualified people in, but we may later revise it in order to expand it to include other private investors. And that reflects the more limited scope of permitted outreach to qualified investors, not to the new new expanded categories. In the
No,
event
no,
a preferential allotment
no,
is pursued,
no, my lord, what it's
revise
saying,
it in order to reflect the more limited scope of permitted outreach (brackets) available in a quip.
no,
close
my lord,
brackets. Could it mean
respect,
that?
I read that differently, my lord. What it's saying is, the schedule includes potential referrals to be made by Cantor in connection with a quip process, semicolon.
Yes.
In the event of a preferential allotment is pursued, Cantor may revise the schedule at such time in order to reflect the more limited scope of permitted outreach for a preferential allotment.
Well, I know you say that, but since there are only two types of limit we're talking about. One is limit on numbers.
Yes.
The other is limit on investors who can qualify.
Yep.
If it means limit on numbers, in the way you read it, then it has to mean that Cantor is obliged to offer to everybody who's on the schedule, which seems to me quite a surprising interpretation. If it means limited scope, limited in the sense of those who qualified for participation in the relevant form of financing, then you could give it a quite sensible meaning in the way I'd suggested. That's all I'm suggesting.
All right, well, yeah, I made my submission on that.
I don't think it detracts from your point, which is whatever the amendment is, it's by reference to two forms of private financing.
There is that, Laura.
Yeah.
I think
Yeah.
it goes a little bit further, but you've heard what I said. So now moving on to surrounding circumstances. Factual matrix. Paragraphs 46 to 51 of Cantor's skeleton take up 3 whole pages trying to undermine the judge's finding of fact that at the time the contract was entered into, objectively an FPO was not viable and both parties knew this. I think we've been through the evidence on this already, but if I could give you some paragraph numbers where the judge made his findings, 20 to 21. At the time of the contract, its financial position was so poor there was a risk it would not survive. As the economic
These
time.
are the references, speaking for myself, I'm interested in, are those where you say the judge found that it was not contemplated ever, as you put it in your,
Well, my lord, then
in your
it's,
submissions earlier.
Yep.
Not
Yes,
that,
well,
not
well,
that it wasn't contemplated
it is.
immediately as at December.
Yeah, no, well, it was. It's the judge's finding that the parties had ruled out an FPO and no finding. As I say, the burden is on Cantor to come forward with evidence that the parties contemplated that they would be involved in an FPO at some point in the future, and there was never any suggestion of that at the trial.
It's 117.
So
The last sentence is 117, is it essentially?
yes, Lord. But we are just in terms of what the judge said when he refused permission to appeal. Which is at page 125. So it's page 125 of the bundle, paragraph 3. And it's this is the basis upon which the parties had ruled out an FPO as not a possible route. This was the basis upon which the defendant approached the claimant, contrary to the claimant's paragraph 6. The relevant matters being self-evident were in the shared knowledge of both parties.
It seems to me to make it rather clearer that it's talking about what the parties considered to be the position in December 2019 rather than for the duration of the agreement.
We will come on, my lord, to see what the parties did have in mind would happen if private finance wasn't raised, which was that there would be an intervention by the RBI. The last thing anyone was thinking about was an FPO for the reasons that Mr. Banodka set out in his witness statement, which is at paragraph 48 of the judgment, which is that there was insufficient public confidence and demand for public financing. Disclosures would have to be given. Might have sparked a row on the bank, and raising private capital was the only viable option.
None of that applied in July, did it? As we now know.
Yes,
that was the position the previous December.
Well, my lord, that was the position in December, and that was the basis upon which the judge said Cantor were appointed, that forget an FPO, what we need to do here is raise private finance. We can't possibly publicise our financial position. Your role is to try and bring in financial investors from outside to shore up the bank's capital.
So 20 and 21, 48 and 49, and 117.
48. 115, this is where some references, some cross-examination, paragraph 115.
Okay.
So this is Mr. Kaplan found it hard not to agree with Mr. Banodka's evidence that a public offering could not take place. At 110 to 113. There is a finding of the judge at 111 that Mr. Kaplan accepted the situation was urgent. (112). I've also noted above my view that these circumstances made it obvious that an FPO was not a possible solution, and that an FPO only became possible because of Cantor's efforts to raise capital did not bear fruit prior to the intervention of the RBI. And this is why the judge in our submission correctly held to paragraph 120 when testing out his ordinary natural meaning of the words, his construction that he'd given to him. That's why he said it was the surrounding circumstances make it unlikely the parties intended Cantor to be involved in an FPO. They are more consistent with the word private, modifying not only placement but also offering and other sale. One has to bear in mind that this was undoubtedly an urgent fundraiser, and that is what the parties were trying to solve, the problem of the immediate lack of capital, and as we'll see, the threat of intervention by the RBI. Yeah, perhaps it would be a convenient moment just to move on to our additional points on the respondent's notice, where some of the documents are relevant to what we say, and also put in shed a bit of light on the judge's findings as to why he said that an FPO was not viable and that the only viable option was private financing. And this concerns the genesis and aim of the engagement letter and the opening words in paragraph 1 of the engagement letter, which state we, Cantor, have been advised by the company, Yes Bank, contemplating one or more financings. And we submit that the judge ought to have found that the only form of financing contemplated by Yes Bank and advised to Cantor was private financing, and that Yes Bank advised Cantor that it was engaged to raise urgent private finance in the financial circumstances that Yes Bank found itself in to avoid intervention by the RBI. It was certainly not contemplated or advised as an FPO would be undertaken. Cantor's first point is that the words in paragraph 1 are preamble, and we respectfully submit that's just quite wrong. If parties wish to define their agreement by reference to what has been advised to them, the court should give effect to it. There's no reason why it shouldn't. The judge in paragraph 121 to 122 did indeed accept that those words, albeit unusual, were perfectly enforceable and should be given effect to. What he went on to find was, I can't find on the evidence that Cantor specifically advised, Yes Bank specifically advised Cantor that this is a private placement. So turning to those facts, it's common ground that the engagement letter came about following discussions between Yes Bank's managing director, Mr. Gill, and Cantor's president, Mr. Jain. Neither gave evidence, as we've heard. Mr. Gill no longer works for the bank. Mr. Jain is unfortunately no longer with us. And the judge dealt with what passed between them at 123 to 133. Starting with 126, the judge found it was unlikely Mr. Gill told Mr. Jain that Yes Bank was contemplating an FPO. That's obviously right. So we know he didn't tell him about an FPO that it was contemplated.
Sorry, what?
So it's 126 rule.
Yeah.
So it's the last sentence.
Yeah.
Unlikely that Mr. Gill told Mr. Jain in positive terms that Yes Bank was hoping for this outcome, which is an FPO.
Hoping for this outcome rather than contemplating it as a possibility.
So, yeah, it wasn't even hoping for that rule. Yes.
I don't suppose anybody was hoping for it. That's not the immediate imperative was to avoid state bank intervention, but that's not the same. It's saying it wasn't contemplated.
Not having it in mind that it might happen.
And speaking for myself, I'm really interested in what you can point to, which would be simply inconsistent with there having been a conversation between Mr. Gill and Mr. Jain along the lines of, clearly we don't want the Reserve Bank to be involved, and we need to raise all this privately. It's just possible we completely fail on that, and I suppose it's possible that 6 months down the line the government intervention will have involved pumping in funds from SBI or some other government-owned, and it may be that the position will look different then. But for the moment, that's not what we want. Suppose they had had that as an express conversation, so that if the judge had known that, he would have had to find that there was contemplated as a possibility, albeit not a hopeful result, that there might be a public intervention which sufficiently strengthened the company for a public offering to be feasible. Is there anything in the evidence that the judge recites and accepts which is just flatly inconsistent with the possibility of such a conversation? That's really, because if there isn't, I'm myself having difficulty in how you can say the judge ought to have made a factual finding that he didn't,
All right,
in
well,
circumstances where he was very conscious that he didn't have
Yes,
an insight into what had been said between those two principals.
I understand. Well, shall I just show you then the 6 documents that we rely on, and see if that advances our case board. So, just to put it into context, we know the engagement letter was signed on the 18th of December, and we know that Mr. Gill and Mr. Jane were in contact by the 7th of December. First document is a board minute, which is at supplemental bundle 182.
So 182.
This is 182 of the supplemental bundle. This is a board minute on Yes Bank's of Yes Bank's board on the 10th of December. 182. The last person named under the directors present is Mr. Gill. Now, this is a document the judge didn't refer to. And over the page at page 184, under the heading proposal for raising of capital by issue of equity shares on preferential basis, it's recorded that at the outset the chairman mentioned that in his email dated the 2nd of December 2019 he has made certain observations which were produced as under. As spoken, please prepare a self-contained note on preferential allotment of shares, including the process to be followed and various steps involved, right from board approval to EGM approval and subsequently actual allotment with collection of allotment money. So that was what's being considered at the 2nd of December, simply a preferential allotment. If one goes over the page to 188, second paragraph down, the board, after detailed deliberations, recommended that the approval for preferential allotment will be done only after the money of the investors had been ring-fenced. Next paragraph, the MD and CEO, that's Mr. Gill, also proposed that the board should consider giving an enabling approval that would allow the bank to consider a quit post-SEBI dispensation or completion of the 6-month cooling period from the last script. There had already been a quit that year and there has to be a 6-month period between the two. However, the board were of the view that the same should be considered after the management proposal for preferential issue is put up for final approval. Then going down to the last paragraph on that page, the board further directed the management that the next board meeting on capital raising should be convened after all requirements for making preferential allotment to named investors / potential new investors as per current stock exchange intimation are fully complied by these investors. So as at the 10th of December, as dated this board meeting, all that was being contemplated by the board was a preferential allotment. Mr. Gill had raised the possibility of a quit, but the board said no, let's focus on preferential allotment. Second document is at page 179.
179.
A document not referred to by the judge. It's the middle email from Mr. Sage Kelly, who is a managing director at Cantor, to Mr. Banodka, the CFO. It's nice to meet you over email. I'm the global head of investment banking at Cantor and wanted to follow up on Anshu, that's Mr. Jain, discussion with Ravneet, that's Mr. Gill. We're excited to have the opportunity to work with your team and are confident we will add significant value on the bank's capital raise initiatives through our unique access to differentiated global pools of capital. Those initiatives at that time were only preferential allotment and the possibility that Mr. Gill had raised of, well, we should consider a quit. 202, moving on now to the 12th of December. And this is an internal Cantor email, and we're looking at the one which starts just above in the middle of the page from Vikram Scythian to Terence Tan, 2 employees of Cantor, on the 12th of December, and that it starts off with 3 types of offering. Registered offering, that's an FPO, not an option. Not an option. And then it goes on to consider quip and preferential issue. You see those capitalised terms there.
Yeah.
So they've ruled out an FPO in our submission. 4th document is at page 231, not referred to by the judge. This is Cantor in
page again.
Sorry, 200. It's 200 and let's start at 228, my lord, which is internal Cantor document called discussion materials, and on page 231. This is dated the 14th of December.
This isn't a presentation, it's an internal.
It's an internal Cantor document, lady. That's right. And on page 231, it's headed up Project Yukon. That was the name given to this project. Financing alternatives. Second line down, qualified institutional placement and preferential allotment are 2 ways in which firms privately place equity in India. And then you have 2 columns which goes through the pros and cons of a qualified institutional placement, equip, and preferential allotment. There is no mention at all of a further public offering. We do submit that's only consistent with Mr. Gill having told Mr. Jane that yes, was contemplating private forms of financing. Whilst on this document, at page 232 over the page, there is a timeline. And that, if one sees, it's about halfway down the page in bold. Finalise investors and calculate offering price 01/23. That's the 23rd of January. Board of Directors meeting date, and the pricing date is the 23rd of January. And we will come on to see that Yes Bank had been given a date at the end of January by the RBI as to when it should shore up its capital. And this is a timeline which was intended to comply with that deadline. No mention of an FPO.
Well, there was no evidence of that at all. There was no evidence that Cantor was even aware of that deadline. So,
Well,
Sorry, there's no evidence that Cantor.
the document my friend's about to refer to is from the Reserve Bank of India, and there was no evidence that was ever shown to Cantor. Indeed, Mr. Penotka hadn't even seen it. So there was no evidence that this timeline, whatever it is, was in order to comply with some Reserve Bank of India requirement, because there's no evidence that Cantor knew of such a requirement.
I'm not sure how that's a point that helps you, Mr. Taylor. If these forms of financing were only the forms of financing which were contemplated within a short time scale, whether it be to the end of January or possibly even bottom right to the end of March, and the agreement was entered into on the basis that remuneration would be paid if there was a relevant form of financing over a period of 18 months. How does it help you to show what was being contemplated in the first month or 2 or 3?
because, my lord, it is the only thing that was being contemplated,
Yes.
private finance.
In the first 3 months?
Well, my lord, at all. There is no evidence that anyone was contemplating an FPO. What was in Yes Bank's contemplation is what Mr. Penotka said in his statement, which is we need private financing, and that is what was advised to Cantor when one applying the words in the engagement letter.
Yeah, that's what we need now. Non constat. If something has happened in 6 months' time, we won't need public finance in a different form. We're just going over it. It's whether it's what are we contemplating now, or what are we contemplating ever. That's the distinction that one has to look at.
Well, it's what was advised, my lord. The wording in the engagement letter is what was contemplated and advised.
Yes.
So
We don't know what the conversations between Mr. Gill and Mr. Jane were, but you're showing us these documents to show that they can only have been that public finance was a never, as far as they were concerned.
Well, I'm showing that what was advised was we need to raise private finance, and the judge himself said it was never advised that we're looking to do an FPO. Effectively, that's the passage that I took you to from the judge's judgment about FPO. That unlikely that would have been mentioned by Mr. Gill to Mr. Jane.
Yeah.
Okay. So then we come on to the draft engagement letter, which is at S page 206, supplemental bundle 206. So this is a covering email on 13th of December, so we're just a few days before it's signed. This is a draft that's sent by by Cantor to Yes. And if you go to page 212 is the first page of the attached letter. You'll see some track changes in there. And then 214, the relevant comments. So the first one is one which starts, please discuss this as a private placement. That is a comment by Yes Bank. It's page 214. And they are commenting on the clause that we looked at earlier on today about how they were, clause 5, about lead book running managers. And Yes Bank is saying, why are you talking about that? This is a private placement. To which Cantor replies, book running titles are often given in equity offerings regardless of whether the offering is structured as an underwritten offering or a private placement on a best efforts basis. Both of them are talking about private placements. And 219, this is a comment about the representations and warranties that the company would give to Cantor. And it's a comment on H2. The company agrees that Cantor shall be entitled to rely on the representations and warranties of the company contained in the purchase agreements as if they were made directly to Cantor. And the comment is by Yes Bank at the top. The reps and warranties will be under definite agreements and will be made to the investor. The response is, in any private placement of public equity, it is customary for placement agents to rely on representations that the company makes to investors. Now, what we gain from this is that when queries were raised about terms in the engagement letter, these are comments by the lawyers. They're all talking about private placement. And we just invite the court to ask oneself what Mr. Gill must have told Mr. Jane when he phoned him up asking for Cantor's help. Yes Bank was in dire financial straits. It could not carry out an FPO because of the disclosures that would have to be made public about its parlous financial position. It couldn't carry out a rights issue for the same reason. So Mr. Gill phones up Mr. Jane, and he must have said to him, Yes Bank is seeking to raise private finance, which is what the board had resolved to do.
So H2 didn't get into the final agreement.
Lord, it didn't. No.
Because H2 in the final agreement is H3 in this draft.
Yeah.
So what do we get out of this?
Sorry, my lord.
What do we get out of this?
Well, my lord,
If this wasn't the subject matter of any agreement.
no, my lord, it's the comments where both parties are referring to this as a private placement. So it's the comment bubble at the top, which is Yes Bank. The reps and warranties will be under definitive agreement and will be made to the investor, to which Cantor replies, in any private placement of public equity, it is customary for the placement agents to rely on representations. Now, why would the person who's drafting this document say, no, in a private placement of equity, this is what we do if, in fact, this is meant to extend to an FPO. And what we invite the court to find, as we did with the judge, which is, what must Mr. Gill have told Mr. Jane if the lawyers working on this transaction, when points come up on drafting, say, look, we're trying to draft an agreement concerning a private placement.
It's all in the context of H2, which was talking about warranties in purchase agreements, capitalised. Are they defined? And are they something that
Defined
would
in
exist in a public offering?
They're defined in H1.
Nice.
I think your point is simply that the comment bubble, the comment bubbles indicates that the lawyers thought they were dealing with private
Yes.
placements.
That's the
And
point.
I don't think you're saying anything more than that.
I'm not. No. Well, I do know. So what we have then is all of the documents in our submission point to Mr. Gill having told Mr. Jane, I'm trying to raise private finance. We've got Cantor's own documents which said an FPO was not an option. That's why their financing alternatives document addressed only private forms of finance. And that's why those who were tasked with drafting the letter when points came up said, we're working on a private placement, that's what we're private financing, that's what we're trying to achieve here. And that must have come from the principals. The lawyers wouldn't have decided, well, how wide are we going to make this agreement? It would have come from Mr. Jane, who spoke to Mr. Gill. And as I say, the judge's finding was he didn't think this evidence was strong enough. My learned friend relies on the Volpe decision, and we should quickly just go to that. There's just one paragraph I'd like to bring to your attention on that as to the approach to take. And I accept the hurdle is high. But at paragraph 2, Roman numeral 3, sorry, this is, I do apologise more, it's the authorities bundle, tab 7.
Volpe, yeah.
And what, 147 of the bundle. And Lord Justice Lewison, with whom Lord Justice Melson Snowden agreed, said an appeal court is bound, unless there is compelling reason to the contrary, to assume that the trial judge has taken the whole of the evidence into consideration. The mere fact the judge has not mentioned a specific piece of evidence does not mean that he overlooked it. But we submit that if the judge had looked at the 4 documents that we've identified in our skeleton, 168, 1, 2, 4 and 5, surely he would have said so. This is not a document intensive case. And at 127 he said that there were only 2 documents of any note. So in other words, he's saying that 4 documents that we've identified were not of any note.
Sorry, judgment 127.
Yeah, judgment 127.
You referred to 168 a minute ago. Was that your skeleton?
Sorry,
Just before that, you referred to 168. Was that your skeleton?
no, sorry, that's paragraph 68,
68.
68 of our skeleton, 68,
Thank
1, 2, 4 and 5 set out the documents which the judge didn't refer to, and what the judge said was in 127 that there's only 2 documents of any note. And that either suggests that he did not consider the documents or he didn't think they were significant, and in our submission, when one reads them, they are significant when one is trying to evaluate what Mr. Gill must have told Mr. Jane. So we simply ask the court to consider all of the documents and ask itself, what must Mr. Gill have told Mr. Jane when he phoned him up asking for his help? And in our submission, the only reasonable answer to that is he asked him to assist him with raising private finance. Now, I can just deal shortly with an addition to this point about what the evidence shows was advised to Cantor. And this is that the financing that was contemplated and advised was financing in Yes Bank's financial position at the time and to avoid intervention by the RBI. And we cover this in 76 to 78 of our skeleton. If we go to start with a judgment at 112, the judge found that financing was urgent. And it must have been obvious that the RBI were likely to become involved. Now we say it was obvious, and we say that the evidence supported the conclusion that Mr. Gill told Mr. Jane that Cantor was being appointed to raise urgent finance to avoid that intervention. And there are just 4 documents to look at. One is 176, supplemental bundle 176. This is a letter from the RBI to Mr. Gill, the Managing Director. It's 176 on the 18th of November 2019. The RBI is the supervisor of the bank, and it's done an assessment, as you can see from the heading in bold, as at the 31st of March 2019. Over the page, at page 177, last line, a time-bound risk mitigation plan to be prescribed for the key supervisory concerns based upon recent risk assessment for your bank is enclosed as annex. The risk mitigation plan will be finalised after discussion during the supervisory meetings with the bank. If one goes over to 178, the first entry in the risk mitigation plan is the bank shall shore up its common equity tier 1 capital, and the date to do that by is the 31st of January 2020. The next document is 192. Which is on the 11th of December, an internal email from Mr. Ashwani to Mr. Jane. The mood on Dalal Street is sombre. The stock is down 16% on the day as I write. There are real issues that the bank is questioning on leadership, size of whole and survival of the bank. This gets confidence capital now, or the RBI will be forced to act. Now the judge referred to the first sentence at paragraph 22. He didn't refer to this gets confidence capital now, or the RBI will be forced to act.
So they contemplated involvement of the Reserve Bank if the private financing didn't
Yes,
work in the short term. What intervention by the Reserve Bank did they contemplate?
The evidence doesn't go that far.
Do you have to say that it was an intervention which did not contemplate sufficient injection of funds to make a public offer feasible? Did you?
I wouldn't say I need to go that far, but the there was then some evidence given by Mr. Kaplan at 305 of the bundle.
Sorry, which page?
305. So this is Mr. Kaplan, who's Cantor's main witness. Page 157, line 12. Says, I think the entire team, and me included, worked under the assumption of incredible urgency on behalf of Yes Bank to raise the capital it needed. And then moving down the page to lines page 158, line 1. We knew that the RBI wanted the bank to shore up its capital. That's what we were brought in to do. That was always part of its mandate. Now the word shore up capital are the words that were used in the letter from the RBI.
Mm.
And we submit that based on this evidence, the court should infer that Yes Bank's Cantor must have known that its job was to shore up Yes Bank's capital, because Mr. Gill told Mr. Jain that is what the RBI had told it to do. And that is underlined, we say, by the time frame in the financing alternatives document that I showed you earlier on, where investors were to be finalised by the 23rd of January, before the timeline fixed by the RBI of the 31st of January.
If we look at 157, lines 19 to 21, it looks as though the witness thought that the intervention they were trying to avoid from the RBI was a takeover. Is that a fair inference from that answer?
Yep, that's what it says, my lord, yes. And we do also rely on the fact that as soon as the RBI intervened, that was the last that Cantor was heard of. Didn't do any work after that, so when the intervention came on the 5th of March 2020, that was when Cantor's involvement, real involvement ended. That's the judgment paragraph 50. Which is consistent with Mr. Gill telling Mr. Jain, your job is to shore up the bank's capital and avoid intervention. There is just one point about, just a legal point about the reference in the comment bubbles on the engagement letter. It's a draft. It's in negotiations. There's an issue about whether that is even admissible. If on the wording of the engagement letter we say that issue doesn't arise, it's only if we're looking at the genesis and aim of the contract that the question arises, well, can you look at what was said in the comment bubbles on the engagement letter, because the contract, we say, allows you to look at this material, but we say that even as a matter of common law, the court is allowed to look at the material because it evidences the genesis and aim of the transaction, which was, we're appointing you, Cantor, to raise private finance. That is the genesis of the transaction. My learned friend referred to a Capita Business Services case by Mr. Justice Foxton. That's simply a decision on its facts. Schofield and Smith, we do not, we accept entirely what is said in that case between paragraphs 22 to 26 about the circumstances which exclude looking at prior drafts and negotiations. But the exclusionary rule does not preclude the court from considering documents which show the genesis or objective commercial purpose of a contract, and that's the exception that we rely on in this case. The Schofield case, which my learned friend has been to, I won't take you to it, except for paragraph 38(4) of that judgment. So this is in the authorities bundle. And the dispute was whether all the conversations that had taken place between the parties were admissible on the construction of the agreement. And the Court of Appeal said no, they weren't. At 38(4), the finding was there is no relevant doubt as to the aim, object or commercial purpose of the settlement agreement. As the recitals to it confirm, the settlement agreement was evidently intended to settle the dispute between Barclays and REL and Property and Asquith. That, however, tells one nothing about whether, to safeguard Barclays' contribution claims or otherwise, the settlement agreement was designed to release the joint administrators and Clyde & Co. So what was trying to be done in Schofield and Smith was adduce evidence as to the meaning of a particular clause, and the appellant wanted to say, well, we had an understanding as to what this clause meant. It was never meant to settle any claims against the joint administrators or Clyde & Co. It was only meant to settle my claims against Barclays, and the court said, quite rightly, no, we can't have people coming along telling us what their subjective intentions were, or conversations about what an agreement means. We look at the terms of the agreement to work out what the parties agreed. Our case is quite different. We just simply say that this whole contract started off with a conversation between Mr. Gill and Mr. J, in which we say the evidence shows. Mr. Gill said, we wish to appoint you to act on a private placement, raise private finance for the bank. That is, in our submission, the genesis and the objective aim of the contract. Finally, can I deal with the one remaining point, which is the Hinduja point, which is the point that this only arises if you're against me on construction and the points that we've raised. This is our fallback case that, well, on any view, Hinduja Leyland was not an investor. Briefly, at page 175 of the bundle, we have the annex to the engagement letter, which says, we've looked at it already, which is that point about Indian investors. So it's the final sentence of paragraph A. For purposes of this agreement, investor means any investor that is not a person resident in India, in terms of applicable Indian foreign investment related laws as set forth in Schedule 1 here too. Cantor was well aware that it couldn't introduce investors from India because Yes Bank had different people acting in different parts of the world trying to introduce investors from different parts of the world. And this is clear that Cantor understood this when it approached Hinduja Hinduja Group Limited, and we see that from the supplemental bundle, page 257. This is on the 16th of January. A letter, an email halfway down the page from Mr. Mutter at Cantor to Anand Dixit at Hinduja Group. And the relevant text starts off with, Cantor cannot speak to members of your team present in India unless the below statement can be affirmed by you on email. This is because Hinduja is a multinational company. It's got companies in India, it's got companies around the world. It's part of the group. Please confirm that the work being done by local Indian-based deal team members, including their participation in calls with Cantor, is to support a potential investment by an entity that is not organised, domiciled or resident in India. And the reply was noted and understood. What then happened after this, within about a month or so, is on the 24th of February, the parties agree the amendment agreement, and in the annex to that amendment agreement, the words Hinduja Group appear at page 189 of the bundle. And the short point is one that the Lord referred to this morning, Lord Justice Popplewell, that there was nothing that amended the term that we looked at in the original engagement letter about investors coming from India. And indeed that is referred to or supported by page 187 of the engagement letter amendment. So paragraph 2 says, refers to the schedule attached, which lists Hinduja, but it says, except as specifically amended hereby, the original engagement letter shall remain in full force and effect. Full force and effect means that the clause which says that investors could not come from India remained. So when one looks at the word Hinduja Group, that can only mean members of the Hinduja Group that are resident outside of India, and it is common ground that the company that ended up investing in the FPO was a company called Hinduja Leyland, which is an Indian company.
It's a slightly surprising result, isn't it? I mean, I imagine that most, or at least some of the investors identified in Schedule 1 had no previous presence in India, but there might have been very good reasons, either regulatory or fiscally, for them to incorporate a local subsidiary in order to be the vehicle through which actually to make the investment. Would you say that would be disentitle Cantor to its fee?
Well, if
BlackRock
Rob?
BlackRock decided they were going to invest, and for those purposes they incorporated BlackRock Mumbai PVT Limited as a special purpose vehicle through which to make the investment. You say Cantor don't get the fee.
If those circumstances came around, no doubt Cantor would approach Yes Bank and say, look, I know our agreement says that we can't have Indian investors, and this is BlackRock USA. They say it's more tax efficient if they in fact set up a subsidiary in India and invest through that. Now that's a conversation that may or may not have had to have taken place, but the point is that before any of those kind of conversations take place, the position is that it was Cantor was not entitled to approach Indian companies. And there's no suggestion that Hinduja Leyland was a company that was set up very recently. It's been an Indian company.
Well, but you have the conversation, and you say no, and BlackRock say, well, we want to invest in this. We're going to go ahead and invest. It is a slightly surprising result, isn't it?
Well, Lord, it's we say that commercially the agreement, absent those kind of circumstances, makes sense that Yes Bank had different financial advisors and it was divvying up geographically where they could get their investors from. It didn't want to have more than one investor trying to get people in India, for example. It just wanted one. And
I quite understand that in relation to, say, Hinduja, who already have a presence in India, and the investment might come from a genuine independent commercial operation in India from a commercial operation within the group operating elsewhere. But if Schedule 1 includes, as I mentioned it must, those who don't have existing operations in India, it produces a rather surprising result, doesn't it? Anyway, don't know, that's the one.
okay. Well, those are my submissions. We do say that the judge rightly concluded that the order and natural meaning of the definition of financing in clause 1 comprise any private placement, private offering or private sale, and that conclusion is supported by the other contractual terms and also the factual matrix the judge found. Yep, thank you.
Lord, as briefly as I can, but having said that, can I go back, I'm afraid, to clause 5.1, which is page 171 of the agreement. Can't think at that point. It was, my friend's suggestion was that that could be explained on the basis that Cantor might become regulated and therefore might in that event take that role. The difficulty with that is that that clause is entirely unrestricted as the circumstances in which Cantor has that right. It doesn't put in the qualification of registration under the Indian Act. It's simply a general right to act as lead book running manager, and therefore it can't be explained away, we submit, on the basis that there would be a precondition of registration. The other point made by my Lady Justice Falk was that lead book, as I understand it, lead book running manager could be said to equate with what Cantor is doing in any event, selling its client book. I think the term is used, drumming up a book. We submit that that wouldn't be a correct interpretation of the clause. It refers to acting in a role, acting as lead book running manager, and in the context of the rest of the clause, Roman 2 and 3 also refer to particular positions, acting as co-financial advisor and acting as financial advisor and acting as co-financial advisor. And therefore what the clause is referring to is acting in a role, whatever that role may be is uncertain, but acting in that role as opposed to the general position of drumming up business for clients. It's not referring, we submit, to the role which Cantor was doing in any event for these clients, which was producing its client book in any event. If you go back to clause 1 of the agreement, in fact clause 2 of the agreement, page 169, it was discussed a little bit earlier in submission. I didn't look at it in very much detail in opening, but clause 2 sets out the sub-paragraphs of what Cantor is supposed to be doing in its role as financial advisor, placement agent, and/or arranger, And as was discussed, 2A on its face is at least could include general business advice. There was no evidence of that Indian law, and it would be rather surprising, Indian law restricted Cantor from giving general business advice to Yes Bank. And 2C, solicitation of and the review of proposals received from prospective investors. And therefore the role as catered for in clause 1 and clause 2 included, and we say importantly included based on the judge's findings, the solicitation of prospective investors. That was what they were doing in any event pursuant to clause 2. It's something they could do for all those transactions, whether it's an FPO, an IPO, a rights issue or otherwise, because there was nothing in Indian law precluding it. And given that that was what it was able to do under the terms of the agreement, it would be wrong in clause 5 to characterize that as acting as lead book running manager. On its face, it's something different. It's a position, whatever that position may be, it's something technical. We may end up with a position that clause 5.1 doesn't give us much of a clue one way or the other, because it's very difficult to understand what it means. It does mean, as I submit earlier, that it can't include an FPO, because Cantor wasn't able to act as a lead book running manager on an FPO, therefore it can't include that. And this may be one of the situations where it's simply indecipherable what it means.
The judge said that it did have an established meaning in the United States. He just didn't tell us what it is. That's now.
Moving on from that, another friend was asked, and we submit with respect a very pertinent question, going back to clause 1, which was what would be a private offer but not a private placement? In a sense, that is a core question for the dispute, because if private placement means something, what else can private offer mean that isn't included in private placement, or was put vice versa? And the only answer given was a private placement together with a rights issue, that might be a private offering as suggested. Now, anything might be anything, I suppose, but that is really impossible to reconcile with what we know about the regulations and what we know about this contract. We know that a rights issue is not a private contract because it says that in the Act. It's not within the sense of private. We also know, as was discussed in argument, that for a rights issue to take place, it can take place in several different forms. It will include offers to existing shareholders, and in the case of this bank, there were thousands of existing shareholders, there were many retailing shareholders, and it may also include, as my Lord Justice Popplewell indicated, offers to new shareholders who buy in a private placement and then buy in through a rights issue. So on its face, it is potentially unlimited as to the scope of recipients of a right issue, whether it's existing shareholder amongst the thousands that there were, whether it's renouncees, which is unlimited, or whether it's other investors buying in, which is also on its face unlimited. So in those circumstances, one realizes what a rights issue, the basic elements of a rights issue, it is, we submit, impossible to contend that a rights issue, because it's tacked onto a private placement, could fall within the definition of private offering. Now, so it goes back to my own friend answer to my Lord Justice Popplewell's question. What is there that is a private placement, that is not a private placement, but is a private offering or a private other sale? And we submit there's been no answer to that at all. There is nothing else that is not a private placement that could be a private anything. And that is whether one proceeds on the basis that private placement is a term of art under Indian law, a term of art generally in terms of the financial community, unless there is a good answer for something else, there's no reason to qualify offering or other sale with the word private, because what you are doing is rendering both those terms redundant. No need for them at all if in fact they refer to private. The best interpretation of the words we submit is private placement means what it says, offering or other sale must mean something that's not private. But Your Lordship knows all that arguments. But anyway, in answer to the question, there was none, and we submit significantly there was none. Now, moving on from that, it was said in argument that it was for Cantor to provide evidence that the parties contemplated a further public offer. And there was no evidence put forward of that contemplation. That, we submit, is not the correct approach to construction. It was never incumbent on Cantor to give evidence of its subjective contemplation of the scope of the agreement. That would have obviously been inadmissible. One needs to construe the agreement on the basis of the words which have been used, both those terms that we looked at, but also, importantly, as I have reiterated, the scope, the term of this agreement, the 18 months, during which time the detail or any future position was unknown. It was said that the judge's findings about contemplation were across the duration of the contract. They weren't. They plainly weren't. If you go back to the judgment, please.
Well, the judge doesn't say anywhere, and what's more, they not only was this the position in December 2019, but they expressly
Yes.
said to themselves or said to each other or whatever. By the way, if things changed, it won't be covered by this agreement or whatever.
And that we submit.
There's no forward-looking party, no doubt, because one of them had left the company, the other one was dead, so it was a bit difficult.
Well, there was no evidence at all about what they said, frankly. So all that stuff about look at those bits and pieces of documents, some of which didn't even cross the line, therefore you can infer they must have said X, Y, Z. That was all hopeless, and the judge was right about that. Yeah. Clearly, with respect, this court won't say the judge was wrong about that.
He qualified what he said in that respect twice, both at 113 and in his conclusion at 136, by saying it wasn't viable as matters stood in December 2019.
Exactly. It's 117. These many paragraphs Your Lordship just mentioned. 117 begins on 18th of circumstances known to both the S Bank on 18th of December, and 136, his conclusion, it is supported by the surrounding circumstances from which it was obvious that a public offering, including an FPO, was not viable as matters stood in December 2019. And maybe so.
And the opening words of 113, it's the same language.
Yes. And the documents my friend showed you, most of which are inadmissible, but let's not worry about that at this moment, indicate that they're talking about, as at December 2019 and January 2020, they're not talking about long term. The long term was unknown, was inevitably unknown. Of course, a public offer could have arisen in all sorts of circumstances. In fact, it arose because of the State Bank of India capitalization. Theoretically, there could have been a private placement which capitalized the bank and enabled it to make a further public offer after that as well. It didn't need to be a regulatory intervention. But as at December 19, when Cantor was giving its client book across, there was no restriction, we submit, as a matter of commercial reality, on what was possible. And there was no reason, we submit. One of the difficulties of this case, as ever, is the wording is not always clear. The wording is not always consistent. One has to do the best one can. The sort of case we submit where it's important to stand back and look at the commercial reality. What was Cantor selling to the yes Bank and what they were buying? And that had nothing to do with the type of finance. It only had something to do with the investments. The investments and the investors was what they were buying, and it's what they got, as it turned out, through the FPO. To turn this around and say what Cantor wanted to do was delimit the specific type of financing to be undertaken in December 19, so as to delimit Cantor's entitlement to payment in the future if something else happened, isn't consistent, we say, with commercial realities. That wasn't the bargain that they bought. And I put the hypothetical, one never knows the answer, but if the objective observer asked both of them in December 19, are you restricting this, or are you simply paying for the investments? We submit the answer would be the investments. There's no reason why they would restrict it at the time. It's become relevant because of what happened. At the time, there was no reason to do so because it was an 18-month contract when anything might happen, and all that mattered was investments would be provided. So the judgments was limited. My friend's submissions were limited to the scope of the position in December 19. As soon as one construes the contract by reference to its terms, namely the 18-month contract, you're unshackled by that limitation, and you're simply saying, what was the deal between these commercial parties? And we say, provided the wording is broad enough to include public offerings and rights issues if necessary, which we say it is, the commercial reality is that was the deal between these parties. Can I just pick up a couple more points before I sit down? Annex C of the agreement which was the point about the placement memorandum and the Roman 1, 2, and 3 on page 175. And my Lord Justice Popplewell said, or maybe I misstated, that I was relying on this point as a defensive point to indicate, well, it doesn't show what the defendant says it shows, namely, this is all relating to private documents, because Roman 3 looks beyond private documents. Maybe I hadn't expressed myself properly, but we do say in our skeleton, this is not just a negative point, but it's a positive point in our favour. And we do say in our skeleton, the judge essentially didn't have the courage of his convictions on this point. What he said, if you go to judgment paragraph 107 on page 113, dealing with this very point, they said, the Yes Bank said, well, there you are, they mentioned private placement, but nothing else expressly. And the judge said, well, look at Roman 3, that includes other matters, that's on 106, and therefore it doesn't count. But what he then concludes from that at 107, second sentence, these features do not suggest that a private placement was the only kind of transaction in contemplation. Now, he didn't carry that forward. In a sense, he looked at contemplation in December 2019 based on extrinsic evidence, which we say was inadmissible. What he didn't take from this was, if you actually look at the wording, it looks to be beyond private placements as transactions in contemplation. And therefore, it's not just a defensive point. We say it's a positively in our favour that the agreement did include these further potential documents beyond private placement, consistent generally with our submission that is what these parties were seeking to achieve. Going back, if I can, to clause 1, and the QIP point, the main, or one issue I think my little Chancellor raised on this, which he described as my friend's best point, which may be right, but we can debate about how valuable that is. He said, well, they mentioned QIP and not anything else, and therefore that means that not anything else can't be included. And of course, who knows? The trouble with that is it's an approach to construction by reference to speculation as to why things were drafted.
Well understood.
And it's a difficult approach to construction because one just doesn't know the answer. What the judge said about that, which is on his page 113, paragraph 107. Again. Same paragraph. Is that it suggests no more, this is the first sentence, that the parties regarded a private placement as the most likely route to pursue. And that may well be the case. And it may well be the case that they did regard that as the most likely route to pursue. And it may well be that was in them conscious minds, subjective minds at the time. That doesn't help you very much. But it's an answer of sorts, I think, to your Lordship's point about, well, there you are, they say X, therefore they must mean not Y. Who knows why they drafted it as they did, and that's an answer which is perfectly understandable. Certainly that point isn't sufficient to upset, we submit, the rest of the construction points in our favour. Can I go back to the famous footnote on page 184, and I think I was right about this, that it's the wrong way around, if it means anything, whether that's a good point or not. The way the regulations work is that a private placement is limited, a quip must be to a qualified institutional buyer. So a quip has a qualification as to who can be an investor in a quip, and there's a definition I showed you about what that was.
Yeah.
A preferential allotment has a limit of 200 investors, not including qualified institutional buyers. They're on top. So on any view, I'll try to get this right with the right time. A quip has a broader outreach than a preferential allotment because it can be wider in terms of the personnel. So working out what that means.
It really is the other way around. The preferential allotment is wider as to...
Preferential allotment is wider because it's 200 plus as many qualified institutional buyers as you can find. A quip is just the qualified institutional buyers. Absolutely right. Yours right.
Which are essentially sort of funds and insurance companies.
Yes, it is. So they don't count the number, so it can be the 200 if you want. So it is the wrong way around. It's quite difficult to understand what it means.
No.
I think the only real point to take from that is the same point about the quip in clause 1. They mention a quip here, but not anything else. So I think it's the same answer. We submitted the same answer. So be it. They drafted that in. No one knows why, but it doesn't mean an FPO is excluded. And lastly, on the factual background point, just to reiterate, Learned Friend's submission was that he said there was a need for urgent finance. And we don't disagree with that. The judge found that as a fact, and we don't disagree with that. And that was no doubt the hope that these parties had there would be urgent finance provided. The mistake Yes Bank make repeatedly in this argument is they convert that hope as to what they wanted into the purpose of the agreement. And the difficulty is that the agreement wasn't for work in December 2019, it was for work and or investment over an 18-month period. So the hope that they wanted that they would get urgent finance doesn't convert into anything about the meaning of the agreement. That's why we submit by the term and work backwards in terms of the commercial reality. And that's why much of what Learned Friend said about those documents is irrelevant because they're all looking at the narrow period of time in December. I won't go back to the admissibility point. Most of those documents didn't cross the line. Most of those documents don't actually say anything anyway of any great substance. Most of those documents were anonymous in terms of what they meant and what they don't mean. And the court, with respect, certainly can't interpret this contract by reference to what unknown lawyers may have said in bullet points to the drafting process. That is just so heretical as a means of construction. I really don't want to deal with that at this time of the evening. It doesn't help. We're simply left with the words for what they are. We say they're broad, and we're left with the commercial realities of what this deal was, which we say favours the Cantor approach as opposed to the Yes Bank approach. Ultimately, the Yes Bank's answer is this agreement was broad to include all sorts of private transactions, whatever they may be, but narrow to exclude everything else. And we say, well, why? Maybe that's not a very sophisticated answer to that. But why would these parties agree to that at the time based on this wording? That's the dilemma for the parties, and now, I suppose, for the court. Those are my submissions in reply.
Thank you very much, Mr. Beltrami. Thank you to both teams for interesting submissions. We'll reserve our judgment, obviously. We won't make any promises as to when you'll get a draft, but when you do get a draft, please limit yourselves to typographical and similar corrections, not to inviting the court to reconsider its decision. And please pay attention to the terms of the embargo at the top of the judgment. Apart from that, thank you very much indeed.
Well, thank you.
Court rise, if able.